As the day's schedule wrapped up in the Greenwood County Magistrate Court in Eureka, Kansas, courtroom cameras recorded a conversation between Judge Phyllis Webster and County Attorney Jill Gillette. They were talking about several people who reportedly missed their planned court appearance. While they spoke, Judge Webster realized that a procedural mistake prevented her from taking any action against those who didn't show up. She also suggested that the error might have come from the county attorney's office. Ms. Gillette's reply to the judge's comments quickly sparked a tense back and forth, one that may have placed her professional future at serious risk.
Tanya Sanchez.
We already did Sanchez. We have a Tiana Richardson and a Dustin Newport I still have.
Well, hold on. That's not what I'm showing. What do you have, Missy?
I have Alfonso Caldwell and Tiana Richardson. That Newport bonded out, or no, well, he bonded on ours, and then Lyon County come and got him before.
I noticed. Okay, he was taken off the docket. And what did I do? Mix up Tanya Richardson and Sanchez?
Mm-hmm.
And no one mentioned that I was using the wrong name?
You were using the right name.
Well, and these are my couple that I don't have anything filed to show that they have to be in court. I don't have a summons. I don't have a uniform notice to appear issued by the officer in the ticket.
Judge, the girls filed the ticket earlier today.
Okay, let me see if it's, maybe I just need to double check. Mr. Caldwell.
Mm-hmm. Tickets were issued January 23rd, 25 at 20:59 hours. But
Okay,
today,
well, let me make sure they made it to the file because I'm not seeing that. I don't see that, Ms. Gillette, and until I have filed verification that they had noticed this hearing. I'm not finding that. You're sure they filed them?
Arlene was the one who did it for us.
No, Missy, do you have that where you can look at it? Because I am not seeing it filed. Maybe I need to. No, I think I've already refreshed to see if they've been added. What was that, Missy?
I said they're not showing up in the case yet.
I don't know if upstairs hasn't approved them or what's going on.
I can check.
Would you check? We'll take just a real quick recess because I don't have anything in the file to show they have notice of the hearing, so I can't take any action for their failure to appear without it.
Judge Webster explains that she cannot move forward against the defendants who missed their court dates because there is no filed proof showing they were told to appear. Normally, when someone knowingly skips a scheduled court hearing, a judge is allowed to issue what's known as a bench warrant for that person's arrest. For example, Section 19473(9) of the Kansas statutes gives judges the power to treat the failure to appear on a county code violation as contempt of court and issue a bench warrant. But this rule only applies if the person stays away after receiving notice to appear, as the law clearly states. Even though we don't know exactly what the absent individuals were charged with, proof that they were informed of their court date is necessary to show that they ignored that obligation on purpose. Because of that, it makes perfect sense that Judge Webster chose not to take any action without documentation confirming that the defendants had actually been notified.
Arlene's going to bring the unfiled copy upstairs, Your Honor, but they were submitted this morning by Jessica.
I need the originals. You're thinking the originals are on file somewhere or waiting to be filed? See what Missy finds. Maybe they'll find the originals at the clerk.
What, Judge? I'm sorry, I'm back now.
Well, she said they'll bring up, if I understood Miss Gillette right, they're bringing up copies, but where are the originals?
I think I actually have a copy because I was asking them today about it, so
Well, I
can print you off the copies that I got sent.
copies. I need original documentation that these people had notice of this hearing, either in the form of a returned summons or a citation. And I don't have one of anything to show that they know about this hearing today.
Your Honor, the citations, we get a Xerox of them. We don't get the originals. The originals normally stay either in the file with the sheriff's office now, or they go straight upstairs. But this had to be long formed because it's marijuana. And so,
Well, even with the long form, I would accept, you don't have the originals, Arlene? You have copies? Have those been filed with the clerk?
Yes.
They have been filed. They didn't make it into their file. Do you know why?
Well, because that's the clerks.
Missy, did you check with the clerks?
Yes, I just checked with them and they do not have them. They're not in the queue to approve.
I know they're not in the queue. I looked through the queue. Oh, unless you mean their queue.
Yeah,
Well,
they're,
what I'm going to do, now I'm looking at copies of tickets, and I've seen enough tickets over the years to know these are tickets, and they do appear to be signed by the signature I know as Blake Fisher's, although I'm not an expert in handwriting. But I am not comfortable issuing any kind of failure to appear warrants if there's no documentation in the file. These are just handed to me, but once they are filed, then I would not hesitate to issue warrants for their failures to appear. So I'm going to set these two cases over till next Tuesday. By then, I'm sure that we'll figure out why those haven't been filed. And then if they're not here at that date and time, we'll issue warrants. But they'll have to be given notice of the new date and time. And it looks like they're out of Wichita, Kansas. Yes, so.
If I have to issue new summonses, then it's going to be more than a week because I have to issue them, send them to Wichita, and have them served on them. They have their notices to appear, complaints.
All right, I'll tell you what, I don't.
I don't even get the original anymore.
Just file the copies, whatever, but they have to be filed, Miss Gillette. I have nothing that gives me legal authority to issue failure to appear warrants. I have in the file, and I'm looking at it, a complaint, a probable cause affidavit, a notice that you're going to rely on KBI reports, and that's it. There is nothing in the file to show legally that they have notice of this hearing. So I don't know where the tickets are. I don't know why they're not filed. I understand that someone in your office said they gave them to the clerk. I understand the clerk to say they don't have them. I don't know where they are, but I do not have them, so I cannot issue any kind of warrant for failure to appear. In fact, if you find them and get them in there even today, we can deal with it today rather than trying to issue summonses. Get me something I can legally use. Otherwise,
I'll call Sheriff Samuels and ask him if he can bring the originals out of his file.
I'm not telling you have to do the originals. I'm just telling you, Miss Gillette, I cannot legally issue a warrant, and you know that. You know I have to have verification before I issue a warrant.
And we emailed them to your staff who has them this morning. They were sent to
my secretary is not the clerk of the district court. My secretary is not the custodian for that. They have to be filed.
Up to you. I'm not going to argue with you.
Well, you better not.
We'll just take it up later.
Miss Gillette, who is the judge here? I am not going to accept your behavior. You're putting me in a position where I'm going to have to find you in contempt of court if you're going to act like this.
I don't have the original, Judge. I can't get it to you. We filed them this morning. That's all I can tell you.
Miss Gillette, you are not listening to me, and you're being contemptuous.
The state has contempt immunity. We already briefed this. If you would like us to get them filed again, we will file.
You have contempt immunity? Do you have ethical immunity that you can talk to a judge any way you want and have no repercussions? Is this what you're saying?
Ms. Gillette insists that prosecutors are, as she puts it, immune from being found in contempt of court. Judge Webster responds by reminding her that, as an attorney, she must still follow professional and ethical standards. The U.S. Supreme Court's 1976 decision in Imler v. Pachman did establish that state prosecutors are fully protected from civil lawsuits for money damages when they are carrying out their official duties, such as starting and pursuing criminal cases. In explaining this, the court acknowledged that this protection might leave someone who is truly mistreated without a civil remedy. Still, the justices concluded that limiting a prosecutor's immunity would harm the public by discouraging the strong, confident decision-making needed for the justice system to function properly. However, being shielded from civil suits filed by defendants who believe they were unfairly prosecuted does not mean prosecutors are sheltered from consequences inside the courtroom. That protection does not extend to contempt proceedings. Kansas law, specifically Section 20-1203, gives judges the authority to punish direct contempt, which Section 20-1202 describes as misconduct that occurs right in front of the court. Nothing in the statute suggests that prosecutors are exempt from this rule. In fact, courts have long recognized that attorneys of any kind can be held in contempt for inappropriate behavior. For example, in the 1877 case in Ray Pryor, the Kansas Supreme Court ruled that an attorney may be punished for contempt if they use insulting or disrespectful language in front of the court. The court also emphasized that attorneys carry a special responsibility to show respect and maintain proper conduct when speaking to a judge. An attorney is considered an officer of the court, which means they are expected to protect its integrity and reputation. While members of the legal profession are free to question, critique, and challenge the issues being examined in a case, that freedom comes with an equally important responsibility. They must treat the court with steady courtesy and respect. When an attorney fails to show that respect, they fail in their duties. And if that failure is serious enough, a judge may rightfully use the authority to issue punishment for contempt. I couldn't locate any legal rulings that support Ms. Gillette's claim that prosecutors are immune from contempt, but she did mention that she had briefed the matter, which suggests she believes she has a legitimate legal basis for her view. It would certainly be interesting to read that brief and understand the reasoning she relies on. Even so, whether or not prosecutors in Kansas might claim some form of protection from contempt, Judge Webster correctly noted that attorneys must also follow professional ethics rules. If their behavior crosses certain lines, they can still face consequences. Under Rule 3.5d of the Kansas Rules of Professional Conduct, a lawyer shall not engage in undignified or discourteous conduct degrading to a tribunal, meaning the court itself. Because of this, Ms. Gillette's remarks and tone toward Judge Webster could place her at risk for disciplinary action for failing to meet the standards required of attorneys.
Judge, I will find the originals, whoever has them, and we'll see if we can get them to you. We will get them filed.
And we will finish this later, Ms. Gillette. At this time, Missy, it looks like Ms. Gillette has decided to remove herself from the hearing. As I said, this matter is not over and it will not be tolerated. But for now, we will be in recess.
It's unknown if Ms. Gillette ever faced formal discipline for the incident, but she has since returned to court and interacted with Judge Webster on positive terms. This moment serves as a reminder that even though prosecutors receive certain protections through judicial immunity, they are not shielded from consequences when they act improperly. They are still required to follow the same procedural and administrative rules that apply to everyone involved in the justice system. Judge Webster deserves recognition for refusing to issue warrants for people she did not believe she had the legal authority to have taken into custody. Even though she trusted that the information Ms. Gillette provided was probably accurate, she insisted that the prosecution complete its administrative responsibilities before moving ahead. She did not grant the government any special treatment that she wouldn't extend to an ordinary citizen. It's also important to remember that a single heated moment does not define Ms. Gillette's entire character or suggest that she is unfit for her role as county attorney. Mistakes in paperwork or procedure can be aggravating in any profession. While that doesn't automatically excuse Ms. Gillette's reaction, it does remind us that everyone experiences stressful days, and no one is completely free from frustration at work. If there's a case or courtroom moment you'd like us to explore, feel free to mention it in the comments. Thank you for watching, and don't forget to subscribe and share to help support a more informed community.